Hello everyone, welcome back to my channel. In the last video we were discussing about Article 31, that is right to property, in which we saw that by the First Amendment Act of 1951, two clauses were added to Article 31, that is 31 Clause A and 31 Clause B. And by 25th Amendment Act of 1971, 31 Clause C was added to Article 31 of the Indian Constitution. We discussed Article 31 Clause A in the previous video. In this video, we will be discussing about Article 31 Clause B and 31 Clause C. Let's start with 31 Clause B. Article 31 Clause B was also added by the First Amendment Act of 1951, but it was an advanced version of Clause A. Means we can say that Clause B was more effectual than Clause A. Let's see what is mentioned in this clause. Article 31 Clause B talks about validation of certain acts and regulation. See, this is the actual text of Clause B. We will understand this in simple words. Clause B stated that a ninth schedule will be introduced in the Indian Constitution, in which anything like act, regulation or any law, if inserted, shall not come under judicial review. Now what is this schedule and judicial review? Let me explain you in short so that you can understand the full context of this clause. In simple words, schedules contains extra information about articles. Originally, the Constitution contained 8 schedules, but at present there are 12 schedules in the Indian Constitution. Each schedule deals with different subject. So earlier we had only 8 schedules, and by the First Amendment Act of 1951, 9th schedule was added. So that was small information about schedule. Now what is this judicial review? See, when our constitution was formed, then 3 authorities were created: legislature, executive and judiciary. Purpose of legislature was law formation. The executive was created to implement those laws. And the purpose of the judiciary was to punish all those who do not obey the law. Judicial review is the power of the judiciary with the help of which it can review any action or decision taken by the legislature and executive, whether that action or decision is constitutional or not. And if it is found unconstitutional by the judiciary, then it can be declared void. Got it? Now you must have understood the meaning of schedule and judicial review. Coming back to Clause B of Article 31, in which we just read that if any act, regulation or law if inserted in 9th schedule, then it will not come under judicial review, even if that act is unconstitutional and it is infringing any fundamental right. It cannot be judicially reviewed and cannot be challenged in the Supreme Court. So what happened because of this? That the law-making authorities and the government got more power than judiciary. This amendment was done under Article 31, that is right to property. So initially the acts inserted in the 9th schedule were somehow related to land reforms or development and were for the betterment of the people of India, and also helped to abolish zamindari system from India. But over the time, this 9th schedule started getting misused, in which all those laws started being inserted which were unconstitutional, unreasonable and nowhere related to land reforms, which were infringing the fundamental rights of the people. For example, acts related to reservation system started being inserted in the 9th schedule, which created a lot of controversy in the system, because the government had started finding this an easy option to avoid judicial scrutiny by inserting such acts in the 9th schedule. When the 9th schedule was introduced, there were only 13 acts in it. But with the passage of time, the number of acts increased to 284. So you can imagine at what rate the acts have been inserted in the ninth schedule. All this continued for a long time. But for how long will all this last? It had to be stopped at some point or the other. Finally, in 2007, the Supreme Court gave its judgment in the Iyer Coelho versus State of Tamil Nadu case. In that case, the Supreme Court clearly mentioned that the ninth schedule cannot get blanket immunity from judicial review. This means judiciary cannot be completely restricted to do judicial review of the acts of the ninth schedule. Taking reference of Keshav Nanda Bharti case, the Supreme Court said that judicial review is the part of basic structure of the Indian Constitution. Therefore, you cannot randomly put any act in the ninth schedule and say that it cannot be judicially reviewed. The Supreme Court also mentioned that the entire ninth schedule cannot be judicially reviewed. But all those acts which have been inserted in the ninth schedule after 24th April 1973 can be subject to judicial review on the grounds of contravention of fundamental rights under Article 14, 15, 19, 21 and basic structure of the Indian Constitution. This means if any act inserted in the ninth schedule after 24th April 1973 violates the fundamental rights mentioned in Article 14, 15, 19, 21 and the basic structure of Indian Constitution, then those acts can be reviewed by the judiciary and can be challenged in the Supreme Court. Acts inserted in the ninth schedule before the state will not be reviewed, but the acts after that can be. Now, why did the Supreme Court mention this particular date only? The importance of this date is that on 24th April 1973, Supreme Court's decision on Keshav Nanda Bharti case came, in which the Supreme Court held that the Parliament can make changes in the Constitution but cannot tamper with the basic structure of the Indian Constitution. However, in that decision, it was not specified that what would be included in the basic structure of the Indian Constitution. But it has been said that judicial review is the part of basic structure of the Indian Constitution. And if any fundamental right or basic structure is being violated by any act, then it is the right of the judiciary to review that act. Let us proceed to the next clause of Article 31, that is Article 31 Clause C. First of all, we need to know that when was this clause added in the Indian Constitution. This clause was added to Article 31 by the 25th Amendment Act of 1971. This clause talked about saving of laws giving effect to certain directive principles. Now let's see what actually was said while adding this clause to Article 31. When it was added, it contained two provisions. In the first provision, it was said that notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing the principles specified in Clause B or Clause C of Article 39 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19. And in the second provision, it was said that no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy, provided that where such law is met by the legislature of a state, the provision of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. Now let's try to understand these two provisions in detail. Meaning of the first provision is that if the government makes any law to implement policies of Article 39 Clause B and 39 Clause C, and if that law violates fundamental right mentioned in Article 14 and 19, then it will not be considered void. That is, it will not be considered as violation of Article 14 and 19. Simply, Article 31 Clause C was immune to Article 14 and 19 with respect to 39B and 39C. Now, what is there in these two clauses? See, Article 39 comes under Part 4, that is Directive Principles of State Policy. This Article 31 Clause C was giving immunity to two socialistic directive principles, that is 39 Clause B and 39 Clause C. 39 Clause B says that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. It simply means that the state shall ensure that whatever resources a community will have, it will be distributed equally among all for a common good. There should not be any discrimination while distributing resources of a community. What kind of resources is it talking about? It is talking about resources that comes from mining like coal, forest resources, water or oil resources, etc. And Article 39 Clause C says that the operation of the economic system does not result in the concentration of wealth and means of production of the common detriment. Basically, it talks about equal distribution of wealth. Wealth should not be concentrated at one place or with one person. So the government came up with the tax system to distribute wealth, taking more tax from those who have more money and taking less tax from those who have less money. So you can clearly see that if the government implements such policies, the people will definitely say that discrimination is being done with them. For example, they can say that same tax should be taken from everyone. By taking more tax from us, you are discriminating and violating our fundamental right. But if you see, it is also necessary to implement such policies for the interest of the country. Therefore, while adding Article 31 Clause C, it was said that if government makes any law to implement these two socialistic directive principles, that is 39 Clause B and 39 Clause C, and because of that law, someone's fundamental right mentioned in Article 14 and 19 is violated, then it will not be considered as violation of fundamental right. That was about the first provision. Coming to the second provision, in which it was said that whatever law the government will make to implement these two policies, it will not come under judicial review and cannot be questioned in any court. And if the state government or state legislature makes a law, then it will be approved only when it will get the assent from the president. These were the two provisions of Article 31 Clause C which were added to the Indian Constitution by 25th Amendment Act of 1971. Remember, the year was 1971. In the year 1973, Keshav Nanda Bharti case came, in the judgment of which Supreme Court, while mentioning Article 31 Clause C, said that your first provision is fine. There is no problem in that. But in the second provision, you are taking the power of judicial review. That is wrong. Judicial review is the part of basic structure of Indian Constitution. You make law to implement these policies, but if that law violates the fundamental right, then we can declare it as void. So in that judgment, Supreme Court approved the first provision and struck down the second provision. Now after some time comes the 42nd Amendment Act of 1976, which came at the time of emergency. At that time, the government made an amendment in Article 31 Clause C, in which it was said that the scope of Article 31 Clause C will not extend only to Clause B and C of Article 39, but it will be applied to the entire directive principles of state policy of Part 4. This means if the government makes any law to give effect to any of the directive principles of state policy, not only 39B and C, but all the directive principles of state policy, and if because of that law the fundamental right mentioned in Article 14 and 19 is violated, then it will not be considered as violation of fundamental right. The government said this during 42nd Amendment Act of 1976. But the Supreme Court also gave its answer in the Minerva Mill versus Union of India case 1980. The Supreme Court said that you cannot do this. The scope of Article 31 Clause C will remain only and only till 39B and 39C. You cannot apply it to all directive principles of state policy. DPSP is not a small part of Indian Constitution. It is very vast. So the Supreme Court struck down this point of the government also. So far, whatever we have read in this video and the previous video, we have read everything under Article 31, that is right to property. Let me give you a short summary of previous and today's video. Article 31, that is right to property, was part of fundamental right since our constitution came into force, that is 26 January 1950. Apart from Article 31, right to property was also talked about in Article 19 Clause 1F. When the government started facing problems in acquiring property, then Article 31 was amended. For the first time, it was amended by the First Amendment Act of 1951, when Article 31A was added, in which 5 points were mentioned under which the government could acquire the property. By the First Amendment itself, Article 31 Clause B was also added, in which 9th schedule was introduced. After that, Article 31 Clause C was added by 25th Amendment Act of 1971, in which immunity was given to Clause B and Clause C of Article 39. Now coming to the conclusion of right to property, which was talked about in the 44th Amendment Act of 1978. So by 44th Amendment Act of 1978, right to property means Article 31 and 19 Clause 1F was abolished as fundamental right and made it a legal right under Article 300A in Part 12 of Indian Constitution. Now the question arises that these 3 clauses were introduced under Article 31. Now what will happen to them? So the Supreme Court said that these 3 clauses will as it is remain a part of fundamental rights and will act as exceptions to fundamental right. So that was the story of Article 31, that is right to property. In the next video, we will talk about Article 32, that is right to constitutional remedies.